Okay, good morning, everyone. Welcome. Hello to everyone in the virtual world and everyone that's here with us also. I'm Karen Govern, CEO of the STARability Foundation. And again, I'd like to welcome everyone today who's joining us in person and also virtually. We are delighted to be able to resume our Family Forum series and to be back again at the Naples Therapeutic Writing Center in this wonderful community room. So we want to thank our partners here at NTRC for allowing us to be here. Just a few housekeeping items before we get started. If you are joining us in person, the restrooms are out the door to the right. We have refreshments on the table. Please feel free to get up and help yourself throughout the presentation at any time. Also, masks are required to be worn here in the community room and on the NTRC campus, unless you are actively eating or drinking or presenting. And also please mute your phones if you're here in person. We'd appreciate that. If you are joining us virtually, we are muting everyone's mics to avoid any background noise. And to best view the presentation, if you're doing it from home virtually, we recommend viewing it in side-by-side mode. And the slide up here shows a quick screenshot of how to do this. So at the top of the screen, go to View Options and select side-by-side mode. On this next slide, you'll see how you can adjust the size of the presentation so that if you would like to do so. We'll also put these instructions in the chat. So we've set aside time at the end of the session for questions and ask that you hold your questions until then. And to help us manage questions from both in-person and virtual attendees, we'll ask that if you're joining us via Zoom, you submit your questions via the chat. And you can do that throughout the presentation, but we will address them at the end during the Q&A. So also just to let you know, we'll be recording today's forum and we will share the link later this week. Excuse me, these glasses are good here, but they're terrible when I try to look out to all of you. So, so I'll be doing a lot of this. So before we get started, I'd just like to thank everyone, all of you joining us today, and everyone who contributes to making STARability the thriving organization that it is. That includes our incredible staff, our board members, our volunteers, and all of our community partners. I want to have a special thank you to Lori Sullivan, our Operations and Supportive Services Manager, who is responsible for organizing today's forum. And to all of our staff that are here assisting today, we have Madison McNally, our Program Director for the Trailblazer Academy, Kayla Childs, who's our Director of Communications and Special Initiatives, Hannah Candell, our Admin Assistant and Studio Assistant, and Rachel Johnston, who is our Events and Marketing Manager. And joining us in the audience is Miriam Pereira, our Chief Philanthropy Officer. So thank you all for being here today. So now just a little bit about STARability. Our mission is to transform the lives of individuals with disabilities through social, vocational, and educational connections to the community while strengthening awareness and respect for individual abilities. And at STARability, we shine light on ability, not disability. We offer a full calendar of life-enriching programs for our participants that we call our STAR Connections. And they are offered currently in both the in-person and virtual realms. And our participants can connect and engage with the community through continuing education, arts and creative expression workshops, health and wellness classes, sports leagues, monthly social events, and more. Our pioneering outreach program, the Trailblazer Academy, offers community-based skill development experience for participants, helping them to find employment, become ready for independent living, and also importantly to have meaningful and engaged lives. Our Junior Trailblazer Academy is modeled after our Trailblazer Academy, and it is an after-school program for 14 to 21-year-old students, high school students in the Collier County Public School System. In 2019, we opened our Star store in the Naples Design District. And in addition to selling upscale resale furniture and home decor, the Star store is also home to our Star Made Studio. And this is a blossoming social enterprise where our signature product is hand-poured soy candles made and sold by our participants. And the Star store is also a retail vocational site, training site for our participants. So when COVID-19 forced us to suspend our in-person programs, as it forced everyone in the world to do the same, at STARability, we were determined to stay connected to our participants so that they could continue to be engaged and to learn and to have that social interaction. So we quickly moved our online programs, many of our programs to the online realm, and we've been very pleased with how well our participants have adapted to this online engagement. And we're slowly bringing back more in-person programming, but we plan to continue offering these many programs online. So many of our parents have told us how much their son or daughter have enjoyed and grown from these online programs. So our enriching online programs enable us to offer more program options to our participants, to stay connected with them. And for many participants who live out of town this past year, it's been a great way for them to still continue to stay engaged. And we can also serve people throughout the country who may not have access to in-person programming. So we invite you to pick up a flyer at the registration table for those of you that are here in person to learn more about our innovative online programs. Or anyone can contact our virtual program coordinator, Francesca McAllister, whose information is here on the screen right now. So as we work our way out of the pandemic, we're very much looking forward to reintroducing our in-person programming. So we currently offer some of our programs in person. We've successfully modified our social events, classes, and sports leagues so that we can offer our participants a good in-person experience, but also still maintaining important COVID-19 protocols. So one of the programs we are pleased to continue to offer is this family forum. So we're delighted to have this back again. And so we created this forum based on what we heard over and over again from families, which is that they needed help finding community resources and support. So we reach out to local experts in various areas and invite them here in a panel and to present their knowledge that they can share with all of you, and then also give you an opportunity to ask them questions and about any particular topic. So families expressed a particular interest in learning about the guardianship process. And so today we'll be learning and talking about this important topic. So we are very thankful to our speakers who are here today, Gina Candell and Nancy Ross, so that they're sharing their expertise and experience with the guardianship process. As you can see, Nancy and Gina have known each other for many years. I'm not going to do the math for you or anything like that, but here they are today. Today here and on the screen. So Gina Candell is an associate attorney focusing on estate planning law, and she's also the sister of Hannah Candell, STARability's admin and studio assistant, who is at our registration table today. Gina brings a highly personalized approach to estate planning that is focused on the unique individual needs of her clients. She focuses her practice on estate planning, estate and trust administration, and guardianship. She is passionate about helping her clients plan for their futures and provides guidance, knowledge, and support throughout the process. Nancy Ross is STARability's Individual Academy Plan Specialist. I know that's quite a mouthful, and I'm happy to explain it to you later if you're interested, as will Nancy. But Nancy is an integral part of our team, helping us with our curriculum development for Trailblazer Academy. Nancy is also the proud mother of Jake Ross, who is one of our participants. Originally from Boston, Nancy has worked as a special educator in Massachusetts and for Collier County Public Schools for many years, prior to being appointed as an exceptional student education program specialist at the Collier County Public School District level. So please join me in welcoming Gina and Nancy. And now I will turn the podium over to Gina, who will start her presentation. Hang on there, virtual world.
All right, I'm a little shorter than Karen, so let me, yeah. Hi. And I'll take my mask off for you all. Hi there. And hi to everyone here in the room. So I'm Gina Candell. I am Hannah's sister. And a lot of you also probably know my parents, Mary Lee and Dr. Joseph Candell. So I am the sister of Hannah, and we have a brother, Max, as well. Born and raised here in Naples and grew up here. I went away to school up in New Hampshire at Phillips Exeter Academy, and then for high school. And then for college, I went to WashU in St. Louis, where I studied psychological and brain sciences. So got a little insight into my family and Hannah and our wonderful population that we all love and work with every day, as well as political science and legal studies. After WashU, I went to University of Miami here in Florida. I was tired of that snow and ice, ready for some warmer weather again, where I went for law school. So you'll see a couple letters at the end of my name on the PowerPoint. So the JD, as most of you probably know, it means I'm a lawyer. So I went to law school. And then the LLM, that's my master's of law. So I was crazy. I'm my parents' child. I front loaded the JD into my first 2 years of law school. And then that whole last year, I actually pursued my LLM, my master's of law in estate planning, so that I could focus on estate planning law. And a little part of that is guardianship. And it's a part that a lot of people don't want to talk about or touch, but it's something that is so close to my heart, just due to my family and what I've grown up with, that I am interested in it. And I'm glad that I'm able to hopefully turn some of it into some plain English for all of you today. So let's see, have I hit on everything? And of course, as you've seen, I've known Nancy since before I was born. So she's known me my whole life. So we went with that picture, but I could have shown you some mommy and me video too. All right, Rachel. Hi. So a big first slide, and this is kind of a concept we'll come back to a lot of times. Legislative intent when it comes to guardianship. So if you look at the statutory language, and I promise I'm not going to put a lot of statutory language up, but this was one that was really important. And it says the legislative intent, it is desirable to make available the least restrictive form of guardianship. Again, least restrictive form to assist persons who are only partially incapable of caring for their needs, and that alternatives to guardianship and less restrictive means of assistance, including but not limited to guardian advocates, be explored before a plenary guardian is appointed. So that concept introduces a few different terms that I'll talk about today. So we come back over and over to that idea of least restrictive form of guardianship. And how I interpret that is we're trying to preserve your child or loved one, whoever you are the caretaker for, we're preserving their rights. So this is something a lot of times we just think about as the parents, as the siblings, the caretakers, grandparents. We just kind of go through the process, we fill out the forms, but really, and this is something I've learned from my parents, it's an opportunity to empower our loved ones. It's the least restrictive because we want them to be involved as much as possible, as much as they're able to be. And so it's an opportunity to empower them and educate them. And that's something I really admired that my parents did when they were going through this process, but also during Hannah's entire life and my life and Max's life as well, is to educate us so that we know what we're capable of. And that's really in line with STARability's mission, that we're shining the light on the ability, not disability. So that's a big key concept that's introduced in this first slide. Oh, Rachel, can we go back? Thank you. A few other terms that pop up in here that I'm going to spend some time with today, the big ones: guardianship advocacy, which I'm going to talk about a little bit more. That's becoming more and more popular, and that's a tool that could be very helpful to our population. And then plenary guardianship, and that's a concept where it's a full guardianship, and I'll talk you through what all that entails. And that has historically been what we have been using, and that's what a lot of us probably online or here in this room may have gone through with our loved ones. Okay. So if you look up in the statute, guardianship, and you go online, you pull up Florida Online Sunshine, you look at the language in the law, it'll list all types of guardians. There's going to be guardians for minors, claims of minors, emergency temporary, standby, pre-need for minor, foreign, and then resident guardians. There's a lot of language in there. So these are a couple types. But again, the two that I'm going to focus on are plenary guardianship and guardianship advocacy. I'm also going to use this as a quick moment to introduce a few terms that sometimes come up in the legal world on this topic. So we lawyers, we have our own language. There's all this legalese when really we could talk in plain English, which is what I try to do with my clients every day. So the law, sometimes the language is a little bit sharp. It's not always the most friendly, but it is the legal language. So I'll talk you through some of it. So with our loved ones, when we're pursuing this, they are an incapacitated person. But up until the point, because with the full guardianship, you'd file a petition for incapacity, up until they're declared incapacitated, they are an alleged incapacitated person. So sometimes you'll see that term AIP in some of the documents. We know that they are fully capable, but legally that's the term that sometimes comes up. Additionally, you'll see the term ward. That just means, you know, there's a guardian and there's a ward. Those are really the two parties that we're talking about. Again, another term for our loved ones. A few other things that sometimes come up is domicile. Where do they live? It's their county of residence. So that's for a lot of us, if we're in Collier County, we'd be filing with the Collier County court system. Or if you're in Lee County, we'll be filing with them. So I am a licensed attorney here in Florida. I took and passed the Florida bar. So I can practice throughout Florida, but I am a little more familiar with the court systems that are in the southern half of Florida, although I technically can work throughout the state. And again, it's one of those things, each county has their own quirks and differences. So it's always good to befriend someone in that department at the court. So when you're doing guardianship, that is typically through the probate department at the court. And we have some great clerks in the Collier and Lee County system that are happy to be your friend. And if you get in there early and talk with them during this process, they're very accommodating and they're wonderfully helpful. Those are good people to know. And it's also always nice to know the judge's assistants, the JAs. Those are good people to have be buddies with as well. Okay. All right. So a big area that I'm going to talk about for a while today, natural guardians. That's you all. You are the guardian for your children up until age 18, as you are with any child. You're the guardian. When you go through the guardianship process, the standard process, you might see terms like plenary and limited. So when you're doing guardianship, there can be guardianship of the person or of the property or of both. When we're doing it for our loved ones, it's typically a plenary guardianship of person and property, just so that we can be their caretaker over everything. So plenary is kind of that big term that you might see and that some of you might be a little bit more familiar with from if you've gone through this process or have tried to research it on your own. what I generally think of and what I would probably suggest is this is something to start thinking of and getting ready for as you're heading up to age 18 for your child or loved one. You want to be ready to go because legally speaking, once they turn 18, they are a legal adult. The law sees them as an adult. And some things you would never think about is you go to the doctor. The doctor would talk with your child or loved one. That is their patient, but their patient's now an adult. Can they speak with the parent? Not unless there's express permission. And most doctors in our situations, they've known our families for years and years. The patient, our loved one, our child or sibling or friend, they'll usually say, of course, you can talk with my mom, and that's fine. But legally speaking, the doctor has a patient who's over age 18, something you don't always think about. What if your child or loved one has an encounter with law enforcement or they're in any scenario? They're 18. So guardianship is one of those things you just want to have ready to go right as they're making that legal transition into adulthood. So adjudication of incapacity, again, legalese, it just means what does that process look like? And this is a process that some of you may have gone through already. And I remember I was, Hannah was 18, so I was 16. I was in high school when I watched her go through this process. And it is a full process. It's a lot. And what that looks like is you file with the court a petition for guardianship. And that petition is saying, I am the petitioner and here's who I am and here is the ward or the AIP, the person that I want to be guardian for, and here's why. So you have to file that with the court. Then traditionally you have to file a petition for incapacity where you list off exactly what the rights are that your child may or may not be able to do. And this is an area, even if we're doing a plenary guardianship, you can specify on that petition for incapacity, this is where they're listing the right to marry and to contract and to sue, all of these rights. There are certain things that we might still want to hold on to, the right to vote, the right to retain employment. Those are so important to our population. So we can still hold on to those rights and have a guardianship. Those aren't at odds with each other. That's okay. But during this process, and again, it is a process, you will work with an attorney. Guardians have to have an attorney representing them. But then all of a sudden there's another attorney because the court appoints an attorney for your child or loved one, for the ward. And that is, again, going back to that original idea of least restrictive alternatives and that idea of retaining rights and protecting our loved ones. The court is doing their job. Sometimes you might think it's overkill, we're all on the same page, but the court does appoint an attorney to represent our loved one just to make sure this person really does need a guardianship. So then you've got a guardian for the petitioner, for you all. You've got a guardian for the ward, for your loved one. You filed the petitions, you file an oath saying, yes, I promise I'm taking care of my loved one. This is why I'm doing it. Sometimes you'll designate the resident agent. A lot of times that's your lawyer to receive the court correspondence for you. You also have an application of the guardian. And that's something you have to file at the beginning where you're listing out, you're saying, here's who I am and my date of birth and my education background, where I've lived for the last series of years, as well as, do you have any felony convictions? All of these things they want to know. Are you okay? Are you legally permitted to be your loved one's guardian? So they go through all of this. And again, like my parents showed me through how they did this, they use this as an opportunity to the extent possible to talk about it with my siblings and myself, to talk about it with Max and me, and especially with Hannah, so she understood what's going on. Because sometimes it's a little scary. You have lawyers coming in to your home or calling you up, and you've got all this involved and all these people talking to you about rights and guardianship. It can be a little overwhelming. And with a plenary guardianship, another big part of the process, once we've got all these petitions in, you got an attorney for both sides, is there's a 3-person examining committee. And that's usually made up of a doctor or a psychiatrist, a social worker. These are people that the court has on a Rolodex, and they find 3 of them, they appoint them to you, and then they'll contact you, and they come and talk with your loved one and kind of do a little examination. They get a lay of the land, and then they file a report to the court. So they filed this report, their reports, so 3 reports, a 3-person committee, and at that point, there's a hearing. And this is something where in a COVID world, a lot of this is happening virtually. Will appear by phone. Some courts will have video, but usually by phone. Pre-COVID, this is a good opportunity. You all go to court. And again, this is something you can bring your loved one with you. They have the right to be there, to talk and express their wishes, and incorporate them into this process so that they feel comfortable and confident. And then the judge will, hear everything and then sign off, yes, you are appointed guardian. Beautiful. So you'll get an order of guardianship saying, yes, the judge is signing off on it, they have ordered it, as well as letters of guardianship that you can keep on you and say, I am my child or loved one's guardian, official by the court. I have my order and letters. And then, as if it wasn't already complicated enough, there is an annual requirement. So you have become your child's guardian. Wonderful. That's the big part. That's the part that takes the most time and money at that beginning. But then each year, usually it's within 90 days of when that order and letters are issued. Each year subsequently, there's going to be an annual requirement. And so that involves an annual report of the person where you're listing out what social services has my loved one received, has the ward received, where have they lived over the course of this past year, what have they been up to, what is their medical history looking like, basically how am I taking care of my loved one, how have they been cared for in this past year. So you submit that. And then if there are any particular financial assets, sometimes the court will require the annual accounting as well. If the assets are just limited to their Social Security income, the court can waive that. Or if there really aren't any major assets, the court can waive that. So typically it's the annual plan of person. So you've done your part, you filled out the annual plan, but then you also need to have your doctor fill out the annual physician's report so that the court sees medically too. Your child, A, it's proof that they've seen a doctor, and B, it's that the court is saying this doctor has signed off, my loved one, my child, they still need a guardian. And this is all kosher. Again, that core idea, we are trying to protect and care for our loved ones. And that's what our goal certainly is, and the court is having to uphold their end as well. That's what they're looking for. Sometimes with that annual report, I will tell you, that year comes and goes and you go, oh my gosh, it needs to be filed. It might not be in the calendar. You can get a clerk's reminder letter, and that's a scary looking letter. It looks very official, and you think, oh my gosh, I'm in trouble with the law. It's a clerk's reminder letter. It truly is that. It's a reminder. They're saying, hey, you need to file this, and we do, absolutely, but please, it's no need for a panic attack or full-blown worry. It is anything that you get from the court, it's going to look a little scary. So I know some of the people behind it that are sending these letters out, and they're lovely human beings. So that's a little bit of an insight into what that process looks like. I will also mention that sometimes once you've been appointed guardian, they may have an education requirement. Typically that's an 8-hour course, as if living our whole lives for these last 18 years wasn't enough of an education. But a lot of times with our types of guardianship, when it's a family members, the court can waive that requirement. In many cases, that might not be required for everyone, because again, we've lived with our loved one for 18 years at that point. We know what the education would look like. So let's see. So that, as I said, that's a big, long process. That is a lot of things, a lot of moving parts. It's very involved and complicated. So why are we having this big 3-person examining committee to tell us our child is incapacitated, the legal term, when we've had 18 years of already knowing that? We're well aware of that fact. And a judge here in Florida had the same thought. They said, we're paying 3 people to be on an examining committee. They have to write these reports. It becomes even longer and more drawn out. Why are we doing this? So they introduced Guardianship Advocacy that got rid of the 3-person examining committee. So this is a concept that I'm going to spend a little time on today because it probably does apply to a lot of our population that is in STARability, or that we have as our child or loved one. So the statutory language, again, I'll just use a little snippet. So a guardian advocate. The circuit court may appoint a guardian advocate without an adjudication of incapacity. So without that big 3-person examining committee for a person with developmental disabilities, if the person lacks the capacity to do some, but not all, of the tasks necessary to care for his or her person, property, or estate, or if the person has voluntarily petitioned for the appointment of a guardian advocate. So those core concepts, without an adjudication of incapacity, you don't have to go through that process with the 3 people coming in and writing reports. You still will have an attorney appointed for your loved one, because again, the court has got to preserve their rights. And again, you can focus on that being an empowering thing. You are making sure that your loved one is part of the process and that they are being heard as well. But typically this guardian advocacy, we're all pretty much on the same page. We want what's best for our loved one. So we don't have the examining committee, and it's for a person with developmental disabilities. So because we're lawyers, what does developmental disabilities mean? So who would qualify under the language? So who qualifies? So under one of our statutes, a person is considered to have a developmental disability if she or he has been diagnosed with mental retardation, cerebral palsy, autism, spina bifida, Prader-Willi, Down syndrome, or Phelan-McDermid syndromes that manifested before age 18 and constitutes a substantial handicap that can be expected to continue indefinitely. So under that, a lot of people can qualify with guardianship advocacy. This really truly can apply to a lot of our population that we're working with. All right. So, can we go back one just real quickly? Thank you. So with the guardianship advocacy, it still is a bit of a process. You as the guardian don't technically with guardianship advocacy have to have an attorney representing you. So that can save on some fees, which is great. But when you are getting appointed, a lot of times you will want to have that attorney for you because you're going to need that hand holding through the legal system. It is overwhelming and a little bit scary. So with that, you'll go through, you'll apply. You still have to file your petition for guardianship advocacy. You still have to fill out your application saying, here's who I am, here's my credentials. The court will still appoint that attorney for your loved one. And typically with guardianship advocacy, they're all on the same page. I've done 1 or 2 of these before, and you talk with the other attorney. Okay, we're all knowing what the facts of this case are. We're all in agreement that this is okay. You have that hearing with the judge, but at that point, it's kind of the formality. They've seen the physician's report, they've seen your petition, they know, okay, this is a guardianship advocacy. It's a little bit like everyone knows what's going to happen. We know where we're headed with this one. So that's good. And with a guardianship advocacy, still a bummer. You still have that annual requirement, but it's a good chance to check in. And I kind of like to think of it as each year you're looking at what social services have we received and what medical treatments, and you get to have a little bit of an update of, oh, wow, look how far we've come in the last year. So at that point, it's just the annual filing, it's the annual report and the physician's report. And I have copies of those. So at the end, you can kind of take a look at what a generic one might look like. And maybe in a wrap-up email, we might be able to send out PDFs of what that looks like for you. So you can get a little bit more familiar with it. And so it's not so scary. Okay. So we spent plenty of time talking about the process and about our loved ones, but now we can talk about you, the guardian. Who can be appointed as a guardian of a resident ward, of our loved one? Who can be a guardian? So if you're in Florida, anyone over age 18, if we're doing a Florida guardianship, they can be appointed as a guardian. They can't have any criminal history. There are certain requirements there, but anyone over age 18. Or you can be a guardian as long as you are connected by blood relation or by certain statutorily defined relationships with the person that you're seeking guardianship for. So sometimes if you're looking in the statutory language and you're looking at things that may be involved, a big thing that courts do look at is, are there advanced directives for healthcare? Are there advanced directives in place? Now, for our population, we're talking about guardianship when they become adults, so they probably haven't done full estate planning. But if this is an area that you can kind of think about on your end with your estate planning, thinking, okay, you know what, let me make sure I, in my documents, say that if I'm not able to, here's who I would nominate to be the backup for my child. So you can't directly appoint them, but you can nominate them. And that's something, a paragraph that might go in your will, for example. So in your will, you can say, if I am not here and my spouse is not here, I nominate this person or this person. So that's kind of the court would see that at that time where they would need to make that decision and say, okay, here's who they would like to have served. So it basically kind of streamlines it and makes it a little bit easier for them to say, okay, we're all on board. We see what the wishes were. So the court, when they're looking at the guardian, they are thinking, okay, there are some considerations they have to take into account. So they look at that application again. They look at the criminal history. And so that kind of brings us to some of those other bullet points, the application I've spoken about, and I have a copy of it. So for those of you in person, you can maybe take a look at the end or swing by the table and talk with me about that. And we can try and send out a PDF of what that looks like in the wrap-up email. The court does want to make sure that you truly are okay to care for your loved one. So they do require a background check. You just have to submit a credit or criminal history to them so they know, okay, we are leaving this ward, this person with disabilities in the hands of someone who is capable. And then again, like I talked about, those education requirements, but for a lot of us, they can get waived because again, we've had a lifetime of education on this. All right. So special needs trusts, I know that's a hot topic. Again, that kind of links into doing your estate planning for you all. And so this is what I do every day with estate planning. That's kind of the majority of what I do with my practice is estate planning. And then guardianship is something that is just a treat. But with basic estate planning, generally speaking, you'll have 6 core documents, 3 healthcare and 3 medical. So on the healthcare side, you do a HIPAA release saying, here's who the doctors can talk to, a living will about end of life, healthcare decisions, a healthcare surrogate, where it's here's who the doctors can talk with just general healthcare procedures. Then on the financial side, and this is where it kind of gets all looped in, you would have a power of attorney, a will, and a trust. So a lot of people only think of a will like as their main document. Oh, I've got a will I'm taking care of. But what we generally do is we actually do pour over wills a lot of the time. And then you have a trust. So what the will says is, oops, I forgot to listen to my attorney. Something's not in the name of my trust already. I forgot to set that up. So the will just says it pours on over into my trust. And the trust is the document that's 40, 50 pages, that big stack of papers, that's the one that actually goes into some more detail on how things would be distributed. So let's say you've got 3 kids, you say 1 share to kid A, 1 to kid B, and 1 to kid C. But kid C has autism or has Down syndrome. So you don't want their share going to them outright. So you can build the special needs trust into your estate planning document. You can say 1 share to child C, let's call him Charlie, 1 share to Charlie in the trust noted below. And then you look at the trust loaded below. So again, that's why these documents are so thick. We've got a whole lot in there. And then that special needs trust language can be built into your estate plan. And that special needs trust language, you can have that where it says, here's who I'm naming as my trustee to care for these monies for my child. And the language is there where it says, we're going to preserve these assets for the well-being, the health care, the housing of my child, the social well-being, medical well-being, housing, those types of things that you can use it for, while still maintaining any government benefits they might be receiving. So when we do that trust language, we want to make sure that we're protecting any government assets that they are very much allowed to receive. That's very valid, and that's an asset that they have earned, that they deserve, that they are entitled to. So we make sure when we do that language that we are preserving that and we're keeping the money protected. So asset protection is huge. Sometimes people will ask specifically about ABLE accounts and special needs trusts. ABLE accounts are something that the statute, the language set up so that we can have specific accounts for our loved ones with special needs. And again, you can use that for housing, for medical, for certain expenses that are outlined in the law. And some people say, well, wait, I have that, but not a special needs trust. A lot of times you'll have both. And one of the reasons for that is it depends on the timing of when you set it up, because the law is ever changing, which is a pain for you all, but good for job security for me. So that's good. But again, it's one of those things. It's okay, was it available at the time that I was looking for it? Was it available in my state? Because sometimes you have certain laws that are federal, and then you have others that are state specific. So there's a lot there that comes into play. So if you have more questions on that, I've included some contact information at the end, and we can talk about that a little bit further. Another thing sometimes people will ask is, well, I've got a power of attorney. Can't that cover everything? Isn't that least restrictive? It does cover a lot, but does your loved one, does your child, do they have the capacity to sign the power of attorney? Capacity standards are different for different documents. Typically for that, if they're over 18, they probably can. But having that guardianship in place is a more holistic approach sometimes, and make sure that they are covered in all scenarios, not just in the specific few that may be outlined by statute in the power of attorney, because there's a couple boxes you specifically check off or cross out in that power of attorney document. So that's a little bit on special needs trust. Current legislation, there's always things, again, like I said, the law is ever changing. So that core concept at the beginning of the slide, least restrictive alternative, we've guardianship, plenary, a whole lot of hoops to jump through, the 3-person examining committee. Then we move towards guardianship advocacy, which is really in vogue now and more popular because it is more expedited, and you don't have to have the examining committee. But then you have people that are saying, that's not even least restrictive. We still are going through all these hoops. So there's always, legislation in the pipeline. There's something right now called supported decision-making, SDM. And I believe there's a Florida House Bill 681. It was filed in February of this year, and I think it had its first reading out loud, and it was in committee in March of this year. Again, it's law. It moves at a glacial pace or it speeds ahead. You never know. It took us long enough to get from plenary guardianship to guardianship advocacy. And then between the time it's passed and the time that people actually know how to do it in the court system, who knows? It could take a while. But the idea there is our loved one can make their own decisions, but it's supported decision-making. So it's being supported by the Florida Developmental Disabilities Council. And they've, back a lot of legislation. They'll say, this is what we support, this is what we don't. And they focus a lot on guardianship alternatives. So that's one of those things that I will certainly be keeping my eye on as we move into the future and seeing if there, when votes are cast on this. There have not been any votes yet. There's no vote history. But again, the law is ever changing, so you have to stay on top of it. Another reason why those annual reports, while a nuisance, aren't really that bad. It's a good chance to check in, and it's a good reminder. each year to kind of see, okay, where are we? What's the status? That we all kind of get together and have that good update. And it's a nice check-in. All right. So that's just a little bit of information about what guardianship can look like. I'm happy to answer any questions for you. And I will let you know, I started my career here in Florida and in Naples as an attorney with Woolman, Gerke & Associates. Fantastic law firm here in town. And I'm so happy I got to start my career with them. This is my last week with them. And starting on Monday of next week, I am going to be joining Rutzel and Andrus, the firm here in town. And they have locations in other states as well. I'll be here in the Naples office, and I will still be with the Trust and Estates Department. So I'll be doing estate planning, probate, and guardianship, same stuff I'm doing now, but I'll be with Rutzel and Andrus, and I'll be involved with them. So if you're looking to kind of get in there with the legal process, or you have guardian, questions and you want to meet officially with the attorney, I am more than happy to talk with you personally. And then just give me a week or two to get settled in at the new firm. And then I'll actually have a real email address that I can provide. But for now, I've given you my personal email address. Feel free, you can shoot any questions to me, and I'd be happy to set up a time to talk with you, and we can answer anything, and we can delve into it a little bit further, because each case is so fact specific. So you've seen one guardianship, you've seen one guardianship, which is just like our children and our loved ones. You've seen one child with additional needs, you've seen one child with additional needs. They are all so different. So while it's a process, it is specialized to each person. So I'm happy to answer any questions, and I look forward to speaking with you all, but hopefully that provided a little insight into guardianship. And I am honored and thrilled to present, we've got Nancy Ross here, who I've known my whole life, and she has a lot of experience with this. And that's a big main idea, is you're in a room or online with a whole community of people that have experienced guardianship or might know about it. You've got a ton of fantastic resources available to you through STARability, through the parents, your friends, your loved ones in this community. So people like Nancy, they're good resources to have, very, very knowledgeable. So without further ado.
Good morning. Let's see if I need to. Oh, Gina. Let me just make. Hi, everyone. Home in here. So the picture that Gina chose to feature at the beginning of this presentation. So I don't know if any of you noticed how much this effervescent, intelligent, engaging toddler in the Minnie Mouse sweatshirt has changed and how I haven't. Right? You're supposed to say, right. Hi, everyone. It is my honor to be here with you here in home with my family attorney, who'd have thunk 27 years ago. And so Gina asked me to come today to talk with you to give a parent perspective to all of the massive wealth of knowledge in this professional's head regarding our guys and gals and what they need. And when I thought about the title guardianship, the very first thing that came to mind for me was a phrase, one phrase, peace of mind, right? We wake up every morning as parents or caregivers of people with additional needs, and we think, okay, let today be a day that we've got some peace of mind. Let's go to bed tonight having a day that's passed and we have peace of mind. And this whole process that Ms. Kendall, attorney at law, has described to us is a humongous piece of the peace of mind because of where we are in our life experience with our loved ones, right? They're not toddlers anymore. We, by law, lost control of them the day they turned 18. So there are some of you in the room who I served here in Collier County back before I retired from Collier County School District as an ESE specialist, and I took care of your guys and gals IEPs. And there are some of you at home, I recognize a lot of familiar faces whom I might have served in that capacity. So a couple of the anecdotal stories I have to tell, you're going to say, oh yeah, Ross, we heard that one. But as parents of guys and gals with additional needs, what we have more than anything are anecdotal stories, just like we do about our guys and gals who are not additionally needed, who are neurotypical. My favorite story about my Jake, there he is. Oh, look at that. There's a picture of him right here. Had nothing to do with the pictures that were chosen. Jake and his dad picked them out. And you will notice most of the pictures put us at a restaurant table. That's just kind of what we do, take pictures in restaurants. Remember those? Anyway, Jake was 20, and we had acquired plenary guardianship for him when he was 18. And so back in the day, Jake's 33 now, there was no guardian advocacy. It didn't exist. It was sometime while I was at Naples High School as the ESE specialist that came down the pike. And I remember handing some of you paperwork off the internet that said this judge in Orange County had come up with a better, easier way, but it was scary and different and unknown. And so most of us back then went through the process for plenary guardianship. The three people who examined Jake as part of that process were delightful. One was the CEO of hospice. That was something she did on the side. One was a retired physician here in school, here in Collier County. And one was a real estate agent. So what I needed to do is, if you're thinking that if you decide with your legal input that the plenary guardianship might be the way you're going to go, it's not like these people with all this highfalutin knowledge and expertise. It's just three people, just three regular citizens of town who have a desire to work with the court to help us have peace of mind. That being said, so we acquired plenary guardianship for Jake. I think it cost us $1,500 back when Jake was 18, something like that, Gina. And so I want to tell you the court story, because we decided as a family he was absolutely going to go to his guardianship hearing. It's a probate courtroom. It's very small, and the person sitting on the bench is a magistrate. It's not a bang, 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 all hear thee, hear ye. It's a very, it's a more casual experience. So we decided Jake would go. And so when you were in school and the teacher asked a question, you raised your hand, and the teacher called on you, what would you do? Would you keep your hand up for the whole answer? No, as soon as the teacher called on you, you put down your hand, right? So the bailiff says, raise your right hand, Jake Ross, raise your right hand. So he raises his right hand, and the bailiff starts to read him, do you solemnly swear? And he put his hand down. And the bailiff said, son, raise your right hand. Oh. And he raised his hand again, and the bailiff started to read to him, and he put his hand down. So the bailiff said, son, you've got to raise your hand the whole time. So what he did was raise his hand, and he took this hand and he grabbed it and he squeezed it against his head. And then the solemnly swear, da 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 da. And Jake went just like this. Of course I do. And it was great, and everyone laughed. I want to try to, from a parent perspective, depressurize what goes on in the room. Because think about it. Everyone in the room is there for the same reason, and everyone in the room has done this over and over and over. You're not unique or different. You're just another one of the parents in town who are looking to get peace of mind, right? So we have plenary guardianship. Do that plan of the person that Gina described every single year. Madison, did you see yourself in this picture with Jake? Just check it. Thanks. Oh, there we are at tables again. So Jake's getting older and older and older in these pictures. Again, I told you about the restaurants. I left him to decide the pictures. So we have plenary guardianship. Every year we have to do plan of the person. We fill it out the first year. You have, as Gina described, you have the, Gina, what's the name of the document that comes from the magistrate himself? That first document that comes, that you are given guardian. You have the order. So you have the order, and that, you know, you got with your will and you keep that tucked away. But then you've got a letter that says, dear whomever it concerns, Mr. and Mrs. Da, 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 are the plenary guardians of da, 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 ward, da, 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 da. So that, for some reason, because I'm a real type A personality, and I remember ESC Special Education Program Specialist, paper, paper, paper. So I laminate it and I put a copy in the trunk of my husband's car and a copy in the trunk of my car, okay? And in the suitcases, one in the suitcase at all time. So that's just kind of how I type A roll. So off we go to Boca, the restaurant, and lunch with family, and Jake steps off the curb as we leave, and he has twisted his ankle. He was 20. So this is a true story, and I apologize in advance for anyone who's heard it before, because I said it in 59,000 IEPs at Naples High School. Have you done it yet? Have you done it yet? Have you guardians yet? Are you guardians yet? Do you have that peace of mind? So we go to the emergency room because it's swelling up in Boca. Remember, sidebar, do you remember Gina said, everybody in town knows you and knows your son or daughter, and doctors and dentists and hairdressers and foot doctors, and nobody questions you because they know you and the situation. Now we're in a strange place. No one knows him. Put him in a wheelchair in the waiting room. Orderly comes, pushes the wheelchair toward the x-ray room, and he looks back at me and he puts his hands on the door jamb and he says, well, I don't think so. Got that? I don't think so. I'm in a strange place. This is weird. I don't think, I'm right behind him. I don't think so. So the orderly pulls the chair back. He takes his hands down. The orderly brings him back to us. I'm following behind him. What are you doing? Where are you going? He says, 20 years old. He's refusing medical attention. That really happened. Goosebumps. I say, excuse me 1 minute. Type A goes running out to the car and gets the letter. He's going to have an x-ray now. That really happened. Just kind of wrap your brains around that feeling for a second. Peace of mind, right? Other story I have for you. A story of a student who was, whose IEP I was facilitating, and the parents are, we're so glad, we're so glad, we're so glad, we're so glad. He was home alone because he was completely capable of self-protection, being okay. Doorbell rang. It was right after, remember we had 4 hurricanes in a row. Ivan, Florence, remember those 4 hurricanes in a row? So doorbell rang, he went to the door and someone said, your roof is really, and it needs to be, sign here. And he signed. Parents had no idea that he had signed a contract for roof repair. He was probably 21 and was all that. And so guess what document was completely invalid because the parents were plenary guardians? Look at Gina. Peace of mind. Okay, those are true, real stories from parent perspective. So what you're looking at now are the first 2 pages of the plan of the person. Once you've gone through the process, whichever one your lawyer guides you through once a year, you have it's about 5 pages long. There are 8 questions. Done this since he was 18. Am I right, Gina? 8 questions, 5 pages long, something like that, not counting the physician's letter. And in that document, it's sort of kind of like a chance for you to say, and this is where you need to be really, really happy that your child is involved in the STARability program. You get to say all the things that STARability does for your loved one. Social activity, shall we go on? Vocational opportunities, cultural opportunities, educational opportunities. You just go on and on and on. Sidebar, Gina has given you her contact information. She is our voice of expertise in this process. I'm talking to parent to parent. If Gina filters a question from you that she really feels is kind of a parent to parent question, she'll pass you along to me. Please make her your first point of contact. Take advantage of the expertise. Okay. So this has to be filled out every year. First year you do it, you think, oh my gosh, I feel like I'm buying 5 houses. It is a little overwhelming, and it does feel like you're being asked the same question over and over and over again. Type A personality. What do you think I make a copy of after it's done every year? You save that puppy. And guess what you get to do every single year when you're forced to have to fill it out again? You say, oh my gosh, look at the growth. Look at the progress. He wasn't doing that. He wasn't doing that last year. He's doing that now. It's simply all the different parts of an IEP. Learning, the social emotional component, the communication component. Let's talk about how now your guy or gal's been on virtual school. I'm a lifelong learner. And in 23 plus classes a week with math and reading and cultural and discovery, and shall I go on? It's simply a chance to say, wow, we're doing that now. Regarding the physician's letter, a one-pager, our experiences with the amazing people. Thanks, Rachel. He's getting older and older and older in the pictures. Oh, look, we're not sitting at a restaurant table. The physician's letter, and what we've discovered here in Collier County is that the clerk, the probate office, the people at probate office are absolutely fine and dandy to pass along in your packet, your 5 pages plus something from the physician. We have not filled out that physician's letter in a really long time. This court is fine with, after it's done the first time, it'll be done the first time. This court is fine with a simple narrative letter from the doctor. And it's simply calling, hi, it's time again. And the doctor will address that letter because you've taken your guy or gal for their physical checkup. And it simply says, he or she's in great health. These parent guardians are doing an amazing and extraordinary job of facilitating everything wonderful that could be possibly imagined for the sake of this guy or gal. We should all have those guardians as parents. Love you, Dr. So-and-so. This is a simple letter from the doctor. And then the doctor has that on file, right? It's in your guy or gal's permanent file. And then you call the next year and say, need a doctor's letter again. Doesn't change much because you've continued to facilitate the same wonderfulness for your loved one. So the plan of the person at first looks like, where am I going with this? Because the questions seem kind of repetitive. And once it's done, you've got that, you've saved it. And the following year, you get to say things that aren't happening anymore. No, he doesn't go to arts and crafts anymore. He's horseback riding at Naples Therapeutic Riding Center now. He doesn't do that anymore. He does this now. He doesn't do that anymore. He does this now. It's really very easy. I handwrite it right on the form. I use the space they give me. I don't do any additional pages. What I'm trying to do is decompress the ins and outs of what you do every year once you've got guardianship. Your legal counsel will take care of whichever way you should go regarding plenary or advocacy or whatever else comes down the pike legislatively. And then it's up to you. What I do each year is my husband and I know that on January 1, it's time to do the update. We don't even leave it. We used to have it on his birthday. That's January 23rd. Oh my gosh, then it's February 21st. Oh my gosh, we never did the plan of the person. Now we say, Happy New Year, clink our champagne glasses, plan of the person, and just get it done. And never get that letter. That was a scary letter. They're going to take him away from, no. So then, do we have one more slide? I think that one more slide. There he is. There he is. He's pretty cool. He's a pretty cool guy. So you can see why if he put his hands on the door jamb and said to the orderly, I don't think so. You know, unless Jake interacts with you verbally you might not even be aware that there are very many additional needs. So, hi Jake, hey Peppy. And so now I think we're opening up to a question and answer session. 3, 2, 1.
So, thank you. We're so grateful to Gina and Nancy for being part of the STARability family, which is what we are. And you know, as I said in the beginning, these family forums are about giving you resources and support. We're facilitating it. They're here for you. They said they're here for you. Questions, reach out to them, and they will tag team together. So again, just so grateful. So what we're going to do is start with questions from the chat, and then we'll do questions in person, and we'll go back and forth that way. So I'm just going to open up the chat here, and if you could still just stay muted until it's your turn to speak. I'm going to try to go from the first one. Okay. So what the first question we had, and if this is you and you want to add to this question, if you're joining us from Zoom, feel free to unmute. This is from Kim, and she has a question. If you become a guardian advocate in Florida, does it have standing in other states? So I'm going to let Gina come back over here and answer that question.
Ooh, hi there. So, I'm a little shorter, sorry. So that is a fantastic question. And if you are appointed guardian here in Florida, does it have standing in other states? Yes. Other states will respect guardianship. It is something, once you add that order and letter, you are good. However, I will note, if you are permanently moving to another state, there is something in the language. It is important, and people sometimes forget this. You need to let your court know we're moving. And then you'll go to that state and you'll file with them, so it's official on their record. But it will be respected because it was granted. You have the order and letters from the court here in Florida, so other states will respect it. But you do need to give notice that you are having a change of domicile, that you are moving, and then whenever you move somewhere else, you'll need to contact their court system there and figure out what it is you need to file with them. But in terms of if you're just on vacation, if you're traveling to Boca and you twist that ankle, absolutely, they will respect it, whether it's across state lines or here in Florida in another county.
So my real question is what about when you split time?
Oh, when you split time between places. So typically the courts will want to know, okay, where is this person living majority of the time? So if it's majority of the time, that's where you're going to want to file. If they split time and live somewhere else part of the time, yes, the other state will recognize it. It should not be an issue. But that is something that when you're doing the initial filing, you may want that noted and talk with your court and find out, do they have any additional requirements if that's the case? But generally speaking, if you're splitting time, you file and you do all the legal work in the place that you are the majority of the time.
And would that affect benefits?
Would that affect legal government benefits? Yes. That's something where you'd want to talk with your attorney as well as any person that you're working with that's your contact for Social Security benefits, things like that. Typically speaking, again, that's going to be based off of where is their primary residence, where is their domicile. Legally speaking, what is their core address? So even if you're splitting time, just like if you're an adult, we've got plenty of snowbirds here in Florida. A lot of them do that where legally speaking, they're part of the year one place and part of the year here in Naples. It'll just depend on where are they legally registered, where is their address. So if you're going to the DMV, for example, a lot of our loved ones, they might not have driver's licenses, but they are entitled to government IDs. So the government ID would list where they live, and that would be their legal address and where they would need to file. So that's something that we would talk through with any advisors you work with and find out if there are any specifics based on the state that you're splitting time with. But again, it goes back to that place where you live majority of the time, your legal domicile.
Thank you.
Of course.
Okay, next we'll see if there's a question in the audience.
I have actually a related question. Somebody asked, could the guardian live in another state from the Florida ward?
Okay.
So can you repeat the question for the?
Yes, so the question was, can the guardian live in another state from the ward? So going back to who can serve as guardian, typically they want to see a Florida resident over the age of 18 that meets all those background requirements. That is a stand-up person. However, if it is a person related by lineal consanguinity, a blood relationship, or a very specific set of relationships that's outlined in statute, that can apply, that can be okay. So if you are the parent or the sibling or any of these very specific blood relationships or statutorily defined relationships, that can be permissible. And again, that's something you check with your local court. When you've done the filing, you make sure it's okay with them. And generally speaking, when it's a family situation, and it's all the same family and you're all on the same page, you're all looking out for your loved one, if you're meeting those requirements, it should be okay.
Okay, so we have a question from in the audience. Do you?
I just want to ask you about that guardian advocate. Is that what's appointed by the court to determine capacity, correct?
So the question about guardian advocate.
Yes, so it's a question about guardian advocacy and are they determining capacity? So if you're going with guardianship advocacy, you don't actually have to file the petition for incapacity. You don't have to go through the adjudication of incapacity. You already have, you are, according to the statute, you meet that developmental disability requirement already. So you don't have to petition and have the court sign off that you're incapacitated. We don't have the adjudication process for the incapacity. They're simply saying, okay, you fall into these categories. You have this diagnosis from before age 18 that will continue to substantially affect your capability and ability to make decisions for yourself. This person meets those kind of three prongs of that language. Okay, they already qualify. So at that point, there's no petition for incapacity, but there is the petition for appointment of guardian advocate. And I will say, guardian, plenary guardian, guardian advocate, you're getting the full guardianship. It's still the same rights that you're getting. Yes, exactly. So that's a really good thing to clarify. You're getting the same exact rights or whatever rights are specifically delineated. That's fine, it's the same. It's just the process of getting there that they've expedited a bit.
We're going to go to the chat and then Corinne. Okay, so let's see, we have another question here. So question about starting the process. This is from Kawan Low is the email address, sorry. Should the parents start the process for a 17-year-old? And then related to that, what, if they start before age 17 or if they don't and they start after age 18, what are the implications?
Oh, of course. Okay. So if you're doing the full plenary guardianship, if that's what has been determined to be what works for your family, and that's what is best for you all, usually I would say probably 17 and a half. At that half birthday, 6 months before, you might want to really start thinking about it. You'll reach out to your court, find out what they would suggest on their timeline, reach out to an attorney, and that's where you can kind of get your foot in the door and get started, because you will have that examining committee and coordinating those people. It can take time. And with our court systems, they are wonderful. We've got great people working there, but once things are filed, we're on their timeline. So usually with guardianship, though, there's a pretty quick turnaround, especially when it's a guardianship where we're not talking about large amounts of money, or it's the type of guardianship for someone older. If we're doing it for one of our loved ones for these particular reasons, the timeline's okay. If we're going with guardianship advocacy, you've cut out 3 whole people. You don't have that examining committee. So you can have it a little bit faster. And that's the big thing with guardianship advocacy, the process goes a little quicker. So I would say probably 2 or 3 months before your loved one turns 18 might be a good time to get in touch with the local attorney, call the court, find out what is it that they need. That's where you can start really doing your research and figuring all of that out, because that'll give you a good chunk of time to get things filed. I think that's probably a good general idea. In terms of if you're getting appointed after age 18, same process. In terms of, what are the implications of that between age 18 and when they become, a ward with an appointed guardian, at that point, there's that gap. But from the moment you apply and you are granted your order and letters from the court, from that point on, you're their guardian. So there's nothing, bad on your end if you haven't gotten to it yet. There's no crazy negative implications there. It's just, oh, okay, we didn't realize we needed this, or we're getting to it now, and that's fine. So you take it from there and you move forward.
Corinne had a question from the audience.
Yeah, just in the opposite direction in terms of state requirements, there are some houses guardianship is established before. Is it recognized as Florida?
Okay. So
Question.
I'll repeat the question. So we have someone here in the audience that says they have a guardianship in place that was put into effect in New York. Is it valid here in Florida? Yes, it is valid here in Florida. Courts like to acknowledge, and there's that reciprocity, that full faith and credit between states. But if your son is living here in Florida full time, then that's something where you might want to reach out to your local court, call your Lee County with your probate division, and you reach out to them and say, do we need to file anything locally? Because it's just kind of transferring the guardianship locally. And then rather than submitting paperwork each year to New York, if you don't live there, then you could submit it here locally. But that's something where you can talk with the court, find out if they have specific requirements. Generally, they like to have the guardianship legally in place in the court system where the child or the person resides. But is it recognized? Absolutely. Yeah, of course.
Okay, so then a question about from Leslie. What are our options if we cannot afford a multi-thousand-dollar attorney?
Exactly. So that's a really great question, and that's a very real consideration. Legal aid here in town will go through guardianship, and they are able to work with you on that. They have got some great attorneys over there at legal aid. Yeah. Legal aid of Collier County, of Lee County, they've got some great people with legal aid. I'll also say one of the big benefits with guardianship advocacy is that the guardian, him or herself, does not need to be represented by an attorney. That's something different than legal guardianship, the plenary guardianship, where there is an attorney required by law. So with guardianship advocacy, that could be something you do your research, you look it up, you contact legal aid. And again, the judge's assistants, the magistrate's assistants, and the probate court paralegals and clerks there are wonderful. They're your best friends. You talk with them, you find out what are the exact requirements needed. And then from there, you can fill out those forms and submit them annually each year. So there are ways to do it. And again, guardianship is one of those sticky areas where you can do it through legal aid, or you can have an attorney that costs a whole lot of money. But it's something that a lot of people in between, there's not a whole lot of attention paid or representation given to that area. So that's something that I care about a lot. And I'm trying to find ways to make it as accessible as possible, whether that's by educating about guardianship advocacy or figuring out, yes, you can do them handwritten. These are forms that can be submitted to the court. Sometimes you'll send them to the attorney and they want to type them all up, and so it looks beautiful, but now you've got attorney's fees for typing up a document that you can fill out yourself. So there are definitely approaches there, but befriend your probate court paralegals and clerks. They are incredible.
Yes. Question from the audience.
Thank you, Nancy, for your story. We have not run into that. We have guardianship, but we haven't been in a place where we needed it. I don't have our documents in the car. And my question is, now with technology, can you have a snapshot about it on your phone, or is there an app, or how can we always have it accessible?
So the question, great question, was about can these documents be in electronic form rather than paper copies that you carry around with you, either through an app or some other format or electronic file.
The simple solution, of course, would be to just take a photo or scan and have it as a document on your phone, of course. So yes, the answer is yes, and my attorney is nodding yes. You certainly can. But the bigger picture for Jake is that that's something we would not want on his phone. His phone is really vanilla. There's not a whole lot of personal information on his phone that might wind up in the wrong place because of an error he might make in a swipe. But while Gina was talking about how wonderful the people at probate are, and they are, remember I told you the story about Jake being at his hearing in the probate court and having to, can your mother and father, son, could your mother and father be trusted to take care of all of your money? That's what the magistrate said to him. And he said, of course they can. He just kept saying, of course they can. Anyway, you gotta laugh, right? We like him to be part of a process at all times. When that letter, that plan of the person is due, he goes to probate with it completed. He stands at the probate court. He says, hi, he does this whole thing, and here's my papers. And he's very much in the moment with the process because it's another learning opportunity, right? So if we were to need it while we were on the road, in the car, even locally, if it would happen to be needed, we like for him to be able to say, let me get them and have them. But you're right, I should have it on my phone. That was a really good aha moment for me. So thank you.
So I think we have time for a few more questions here. I'm gonna see what we have in the chat. Okay, related to that, is there a typical cost for the guardianship process? Would you care to comment on that, Gina? It depends on the firm. So as Gina said, you can contact several different attorneys, and you can also contact legal aid. That in Collier County, they're a wonderful resource for free legal advice and counsel. So for someone who is fully physically dependent for care is the only option plenary guardianship. So this is a question from Tiffany, if she would like to unmute and comment anymore. Are there further explanation about determinations for eligibility for guardianship advocacy? And again, some physical and communication challenges. So what would be the best option there?
Okay, so let me check out. Let me just read the question real quickly. Okay, for someone who's fully physically dependent for care is the only option plenary guardian. Okay, so based on that question in the chat, are they eligible for guardianship advocacy? So that statute kind of outlines, those specific diagnoses, and has it onset before age 18, and will it continue for the future? One of those things where there's kind of a little bit of wiggle room sometimes is you can talk with your probate court and give them kind of, here is our official diagnosis. And you can try for guardianship advocacy. You can say, we've got all the documentation in place. The court would be the one that would let you know, you need a plenary guardianship for that. But goes back to that very first slide, their goal is the least restrictive alternative. And because you get rid of the 3-person examining committee, if you've got plenty of that documentation and a lifetime of experience and you've got doctors signing off on it, guardianship advocacy is a good route these days. It's becoming more and more accepted, and more people are more aware of it now in the court system. So it's something that they're increasingly open to, and judges and magistrates, like Nancy mentioned, are willing to look at that. So even if it's not that specific diagnosis, call up the probate court and ask them, and you can try and go for guardianship advocacy, because their goal is least restrictive.
Thank you.
Of course.
Another question from the audience? Yes.
We have a special needs trust already in place, but it's in Ohio.
Okay.
Working agreement. So
The question is about a special needs trust set up in another state and transferring it to Florida.
Got it. So when you have that special needs trust, it's in effect in Ohio, it's a valid trust. That's perfectly valid here in Florida. Sometimes if you're doing a full update to your estate plan, that might be a good opportunity to bring that trust to the attorney and say, should we Floridize it? Should we do a Florida trust? Can we merge them? There are different ways that you can do that. But that is a good opportunity to check in with your Florida attorney. And we get this question all the time with our snowbirds, which is general estate planning documents. They'll say, oh, well, I have my, New York documents, but we've been in Florida for a while, or we're spending more and more time here. So what we call it, it's not an official term, but we like to have terms for everything. We Floridize, we do a Florida version. And what that means is, rather than having that Ohio language that might be built into the trust, or language that is very specific to Ohio, you can set up and have the Florida version of that trust. So it would have Florida provisions in the background language. So like we talk about with all of our trusts with our clients, the partner, the named partner of my current firm, Edward Woolman at Woolman, Gerke & Associates, he is wonderful. And he has a really fantastic way of explaining trusts to all of the clients. He likes to tell them that it's like the operating agreement, the operating manual in your car. You put it in the glove box and you never read it. That's why it's so thick. It's got all the pages in it. But if the check engine light goes on, if something's wrong, you pull it out, you open it up, and it has all the answers. So that's sort of like what our trusts are like. If the check engine light goes on in life, if something comes up, you pull out the trust, you open it up, and that's where it would be helpful maybe to have some of that Florida language that might be more applicable if he's living in Florida. You can open it up, it'll have all the answers, or better yet, that's where you can call the attorney and they can actually say, oh, well, that's going to be Article 6 subsection 17. So because I tell all my clients this, all the people that come into the office, they're wonderful and lovely. And I tell them, if you ever can't sleep at night, just pull that trust out, start reading, your eyes will glaze right over. It's better than NyQuil, better than Tylenol PM. That's why we have to go to school. We spend a couple of years reading all that language and then years and years practicing it. So that's, again, job security for us. People don't want to look at that language. It's no fun, of course.
And I'd like to ask a related question about Gina, maybe you can comment. Many people consider estate planning, what to do with their assets. So people maybe think, well, if I don't have assets that need planning for, I don't need any of this. But particularly when we have, a loved one with additional needs, it is, advisable to have this trust or estate planning. Would you care to comment on that? Sure.
That's a really fantastic question, and we get this all the time. Earlier this week or last week, we had someone that was saying, well, I moved to Florida and all you guys talk about trusts. What's going on with that? Why do you have all these trusts? I don't have the assets to justify or to warrant a trust. Well, sometimes in Florida, why we like having trusts is because it provides all this creditor protection. So what about your other kids? If you have a share going out to Susie, Billy, and Charlie, Susie and Billy, if they go through a divorce or they're in a car accident, divorce is the #1 creditor. You don't want that share going out to the ex-spouse. You want to keep it in the family. So that's why a lot of estate planning attorneys prepare dynasty documents. So a lot of people will think, oh, estate planning, that has to do with having all this wealth, all this money. We live in Naples, so again, there's a lot of estate planning attorneys here, but it's really something we're going back to that core concept Nancy was talking about, peace of mind. When you have an estate plan in place, you can say, you know, yes, if there's any assets, here's who I'd like them to go to. But just like how we have with an estate plan, it's not just the financial documents, there's the 3 healthcare documents too. It's who can my doctors talk with? It's if I'm incapacitated, who can talk on my behalf? Who can help? Who can, you know, be with me? And that's a big thing with a trust, why those can be so helpful. When does a will come into effect? After you've passed away. Well, what if you haven't passed away yet, but you've become incapacitated? There's elder law issues. That trust, you can now have a successor trustee jump up. So a lot of this estate planning, peace of mind. It's knowing if something happens to me, we've got backups. Here's what the plan is. And the statutory language changes. So every couple of years you might revisit it or you can come back to it. But by having that language in there, by revisiting and thinking about, do I have this in place? It gives you that peace of mind.
Thank you, Gina. Excellent advice. I think we'll do 2 more questions on chat and 2 more in person, unless people are okay staying. We have 2 hours blocked, right? Is that correct? Okay. So also, yes, and we will repost Gina Candel's contact information. So there are a couple questions about divorced parents and having more than one person be a guardian, and also related to the financial impact of that. So if there's shared custody. There are a couple questions, one from Tiffany, one from Chris. So if they want to unmute, if they want to add to this, but come up and address those.
Sure. Hi there. Any extra comments or that you wanted to add, or can I jump in? Okay.
No, if you can jump in. I was just curious, this is Chris, around like when you go to fill these documents out and the court looks at it, again, what do they look at as far as their current situation financially, who's been paying for things? And I guess employment of the individual, does that take into effect? Things like that. I'm just curious how the court would view that.
So historically, you had a lot of courts that were saying we want one guardian, one ward, one-on-one. More and more, I think I've noticed we're moving towards like both parents can be appointed, especially if they are both local. Courts are more willing to look at that. And then one of those types of guardians that was listed earlier was standby guardian. You can say, if I'm not available, here's who I would like, who I nominate as my backup. The court would have to sign off on that. And there are, certain restrictions there with standby guardians. But co-guardians are increasingly becoming something common, especially when it's parents that are married or divorced. So I'll speak with my sister Hannah, my mother and my father, Mary Lee and Joseph Candel, are both the guardians. So there's the 2 of them, which means, yes, it's an extra signature on each line, but no, they didn't need to have 2 different attorneys representing them. They were both the petitioners together. So if you're able to submit the petition together, absolutely, co-guardians are acceptable. It can get a little messier when you have 2 people living out of state, or one in state, one out of state. The court can sign off on that because of that lineal consanguinity, the bloodline relationship that is in the statute as something that's okay. But if that's the case, then the court may prefer having a primary, guardian, and then that standby as a backup. But generally speaking, co-guardians is something that is becoming more accepted. And it might sometimes just depend on your judge. So each judge, each circuit, each courtroom can be different. So again, it's a good chance to befriend that JA, that judicial assistant, or that clerk of court, or paralegal in the probate department. And they've got some good answers there.
I have another question from the audience. Yes.
Does your loved one have a power of attorney, a living will, regular will as well as yourself?
Yeah,
That's a good question.
Yeah. you
So,
can repeat it.
yeah. So does your loved one, your child, the person you're the guardian for, do they also need to have a living will, a will, a power of attorney as well? They absolutely can. If they have the capacity to sign, that's great to have on hand. The guardianship covers just a little bit more, and it's something that if you run into one of these scenarios at, for example, Nancy, the fantastic story that she shares about the medical experience, that's something that might not come into play because you might have designated your parent as your power of attorney, which is wonderful. But if you're the one saying, nope, I don't want to go in, you're still in the driver's seat. So they can't just step in for you if you're still talking on your own behalf. And that's, a lot of times with estate planning, we like to maintain that capacity. And as long as you're able to say what you want for yourself, if your child can say that, your loved one can say that, people are going to look to them first legally. So when you run into those situations, those gaps, those things you wouldn't think about, that's where the guardianship can kind of step in and give you that extra peace of mind. So those are documents that if they have the capacity and the ability to sign, of course you can. But the guardianship, it gives you that extra peace of mind because it covers all those scenarios that don't quite fit into a power of attorney or a living will or a will scenario. Of course.
Okay, so we'll do one more question from chat. So I think we addressed a lot of there. So there was two acronyms here, INFACT and POA. We just addressed power of attorney, but
Okay.
the INFACT, is that something?
Sure. So sometimes it'll say guardian in fact. That's just a legal term of art. It means you are the guardian. Again, we lawyers have our own language. It's legalese. It just makes it more difficult for everyone else to understand. And then on top of it, court by court, state by state, you've got different laws where if something that means one thing in one state might mean something else somewhere else. So it's good to have a friend who's an attorney or, researching online, reading through the statutes, and talking with other parents and family members and friends. You've got a huge community with a wealth of knowledge. If you put together all of our shared life experience with our loved ones, we've got a lot of people from all over, not just in Florida, that can share what they've learned. So that's a really great question.
Any other questions from the audience here? No, for my team, is there anything else in the chat that we should address yes, Laura?
There was a question about what if two people want guardianship and disagree on those things.
Okay, so yeah, the question is if two people want guardianship but disagree on what's best for the ward. So, good question.
So that moves more into, sometimes it could involve litigation. I'm not a litigator. I went into transactional law. I'm generally a pretty friendly attorney, a friendly person. So I figured let's stick with transactional. When you do have disagreements like that, that's where you're going to have more probably court costs or more hearings on the book. That's where when there's that type of disagreement that comes up regularly, if it's the type of thing that is, you're not reaching a conclusion, that is something sometimes that you'll have a hearing on and a judge or a magistrate may weigh in and issue kind of their edict, their order. So if you've got two people that are totally at odds and say the child lives with one of them, the loved one lives with one of them, maybe that might be the primary guardian and then the other could be the standby. Who's sort of that secondary if the first one's not able to. That's something to navigate with your court system. But once you start getting into those disagreements, that argument territory, that goes into litigation. I'm not a litigator.
Okay. Is there anything else in the chat?
One other question, why do parents suggest a guardian but don't appoint them?
Yeah.
Okay, the question, why do parents suggest a guardian but don't appoint one?
So in your will, when you talk about the guardianship provision, which if you go to an estate planning attorney and you have children under the age of 18, you'll automatically have that provision in there. And that's usually where you're naming your sibling or, the aunt or the godparents, something like that. And the language that's in those documents is I nominate, because technically speaking, guardianship has to do with someone's rights. And that very first slide, least restrictive, the court is trying to preserve those rights of your loved one. You can't simply say, I'm taking them away and giving them to somebody else. That is something that legally speaking, the court has to appoint. So you can nominate and you can say, courts, here's who I want. And then that is one of the top considerations that the court will take into account. They'll see, oh, this person was on top of it. They have nominated someone, and that'll kind of ease of access, it'll smooth that process out, but legally speaking, we don't have the power to appoint. It's one of those things our judges have.
There's another question from the audience, yes.
If you're traveling internationally, what happens if something happens to your loved one internationally?
Good question about international travel.
International travel. That's a really good question and something that I need to look into a little bit more. Generally speaking, if you were legally appointed in the state, county court, where you got your orders and letters from, that is valid. That will apply elsewhere. Now, communicating that internationally to someone like I am the guardian, that might be a little tougher, but legally it should stand up. But that's an area I'd want to look into more. So that's a very good question.
Excellent. Any more questions from the chat that were not already covered? I know we had a lot of comments, so appreciate everyone's comments. We'll continue to share the contact information. It's in the chat, I believe.
My name is Gina.
Yep, GinaCandel@gmail.com. I think are we good with the questions? So we have, for those of you here, we have some resources at our table. Feel free to pick those up. You have Gina and Nancy's contact information. As they said, feel free to reach out. Thank you to everyone joining us from near and far. This was really, I have to give Lori and Rachel a huge shout out again for making this happen in both these realms. I think it worked out really, really well. And again, we're so grateful to Gina and Nancy for their time today and sharing their experience, expertise, thoughts, and so much wisdom. So thank you on behalf of everyone at STARability. We welcome all of you to contact us with any other questions on our website. Give us a call at the office. We're happy to help. So take care, everyone, and stay well.